All right, the record should reflect that the closing summations are over. The defendant is present with counsel and the district attorney is present. Before reaching the verdict in this matter, the court would like to make two personal statements pertaining to this case. The first, the law as it currently stands in New York State says that a defendant, and only the defendant, has the right to choose if he would like to have a jury trial or a trial before a single judge. Personally, I have never agreed with this law. I think the district attorney should have the right to accept or not accept the request for a non-jury trial. In my opinion, they have an equal stake in the outcome of the trial and should have the opportunity to agree or disagree. I also think that the court should have input, and unless all three agree on a trial before a single judge, then the trial should be heard before a jury. I say this because I have great faith in our jury system. I think that it is a single factor that makes our justice system superior to any other in the world. I also feel that the analysis and insight of 12 people will always be superior to that of one. Jurors often tell me that they have started deliberations with a certain mindset, but changed their opinion after listening to the opinions of their fellow jurors. A single judge does not have the opportunity to listen to the insights of others. His or her decision is made alone. When I started this job, I took an oath that I would uphold and follow the laws of this state. Despite the fact that I disagree with this law that allows the defendant alone to choose whether or not to have a non-jury trial, I will follow the law and abide by his decision. Secondly, I would like to offer my heartfelt condolences to the family of Lauren Belius. There is no harder thing to endure in life for a mother, a father, and even the grandparents than the loss of a child or grandchild, especially in a case like this, where Lauren was such a beautiful, innocent child. As the father of twins, I also know the special bond between two individuals that shared the same womb. Twins are each other's best friend, a person so close that they will always help you, always support you, always nourish you through good times and bad. This special bond should never be broken. It has been broken here, which makes me grieve for Erica Belius, another innocent child that will always be affected by this senseless act. Lastly, it should be clear to everyone that David Trebilcock, and David Trebilcock alone, is solely responsible for this tragedy. No one, and I mean no one, else shares any blame in this loss. In examining this entire case, it is clear that no one could have anticipated that he would take the life of an innocent child. For someone to ever suggest that anyone other than the defendant shares any responsibility shows that they don't know the facts of this case or they have some other twisted agenda. Again, David Trebilcock is solely responsible for this tragedy. There are three charges contained in the indictment: murder in the second degree for causing the death of Lauren Belius, assault in the second degree for causing physical injury to Allison Belius, and criminal possession of a weapon in the first degree for possessing the knife used to kill and injure the two victims. The burden of proof is on the people to prove each of these charges beyond a reasonable doubt. The people have met their burden and, quite frankly, have proven the defendant's guilt beyond all doubt. If I could stop my evaluation here, the defendant would be guilty of all three charges. The defendant has raised the affirmative defense that he lacked criminal responsibility by reason of mental disease. The defendant is alleging that at the time he killed Lauren and hurt Allison Belius, because of his mental disease, he lacked the capacity to know or appreciate either one, the nature and consequences of his conduct, or 2, that such conduct was wrong. Since this is an affirmative defense, the defendant has the burden of proof. This burden of proof is much lower than the people have to prove the crimes, that being beyond a reasonable doubt. The defendant has to prove his affirmative defense by a preponderance of the evidence. A preponderance of the evidence means the greater part of the believable and reliable evidence in terms of its quality and the weight and convincing effect it has. It is often described as a tipping of the scales. Even 51 to 49% is sufficient to meet the defendant's burden. Anyone who sat through this trial understands that this is a critical question before this court. Has the defendant established that a mental disease has prevented him from knowing or appreciating the nature and consequences of his conduct, or that such conduct was wrong? A layperson, including a judge, has very little insight into mental diseases of the mind and how they affect human conduct. During this trial, we had the benefit of hearing from 4 doctors that spent substantial time with the defendant trying to understand his disease. They all had impressive educational backgrounds and had achieved a position in their professional careers where they were qualified to offer an opinion to this court. Each doctor shared the opinion that the defendant suffers from paranoid schizophrenia. That was significant to the court, but in analyzing all of the testimony, the court freely admits that the most persuasive testimony came from Dr. Lawrence Farago. Anyone who heard his testimony had to be impressed with his professionalism and his unique ability to describe complex medical terms and issues in a language that could be understood by all. He did such an exhaustive review of the facts and backgrounds of this case that he rarely, if ever, had to look at his 48-page report. The people in their closing summation were critical of Dr. Farago. The people complained that Dr. Farago never spoke to Lauren Belius prior to reaching his decision. What has not been stated was that he was the people's witness, their expert, who would have done whatever they directed him to do. The people supplied Dr. Farago with the reports he reviewed. They supplied him with the witness statements. They supplied him with the tape recordings of the defendant. They supplied him with the multiple statements of Lauren Belius. They gave him everything that he reviewed and studied. I am sure that if they had directed Dr. Farago to speak with Lauren Belius, that he would have done so. Having not directed him to do this, I think it is unfair at this point that they criticize him for not doing so. Another factor that points to the integrity of Dr. Farago is that he was hired by the district attorney's office, but ended up being a defense witness. His medical opinion is not for sale, no matter who is paying the bill. Frankly, I have not seen a more impressive expert witness in my 16 years on the bench. The last question I asked of Dr. Farago was whether this opinion he rendered about the defendant was a tough or difficult call. He stated that it was not. Everything he looked at and studied pointed to the conclusion that the defendant suffered from paranoid schizophrenia, and this, without question, caused the defendant to lack the capacity to know or appreciate, 1, the nature and consequences of his conduct, and 2, that his conduct was wrong. Dr. Farago's testimony, as well as the similar findings of the 3 other doctors, convinces this court that the defense has met their burden of proving the affirmative defense by a preponderance of the evidence. Therefore, as to the 3 charges contained in the indictment, the court finds that Mr. Trebilcock lacked criminal responsibility by reason of mental disease or defect. Please note that I did not find that the defendant was not guilty. My finding is that he lacked criminal responsibility because of his mental disease or defect. Dr. Farago also testified that, in his opinion, the defendant's prognosis for recovery is poor. Many will probably want to know what will happen to Mr. Trebilcock at this point. Today, I will issue an order to have 2 psychiatrists conduct an examination of the defendant. The defendant will remain in Oneida County Jail until the doctor's reports are completed. These reports will be shared with the district attorney and with defense counsel. After the reports are received, I will hold a hearing to determine if the defendant has a dangerous mental disorder or is mentally ill. If it is determined that the defendant has a dangerous mental disorder, then he will be committed to a secure mental health facility for a 1-year time period. After that first commitment is over, the defendant can be held for further 2-year time periods if he remains mentally ill. Once again, Dr. Farago felt that the prognosis for recovery is poor, so he could spend the rest of his life confined in a secure mental facility. Finally, I would like to thank the attorneys for the fine work that each has done throughout this trial and the professionalism shown to each other and to this court. The court will stand in recess.